Hello everyone, welcome back to my channel. My name is Advocate Rioba. Welcome to Friday. In today's topic, we are going to proceed with the criminal litigation process. This is process where you have been arrested, you have been taken to court and taken plea, you have gone for the first mention, and now you're going for the hearing. All these steps, I have been able to explain to you your rights when you are arrested, what you do at the plea taking session, what you do in the first mention. Now you have received all the documents. You remember from our past video, which I hope you can go back and look at if you haven't, we have already been given documents by the investigating officer. Now, on that hearing, you are not supposed to give evidence. It is for the prosecution to bring their witnesses, which have been stated on the charge sheet. They will bring their witnesses, the complainant, and the investigating officer. So, what do you do on this day? So you've woken up, you have your hearing, you're an accused person, you've been accused of committing a crime. You go on that day with your advocate. You have already looked at all the witness statements, all the investigation diary report, all manner of evidence that have been brought for you to be charged. What is the importance of you going through this document? You're going through these documents for your advocate, for your appointed advocate, to be able to question the prosecution's witnesses so that the court can make a finding if you have a case to answer. I will explain that in a minute. Now, you've woken up on the day of the hearing, you've gone with your advocate to court, your matter has been called. The matter will be called, and the court will ask if the prosecution is ready to proceed with your hearing. So let's say today the prosecution is ready to proceed with your hearing. They will say we have 2 or 3 witnesses according to how many witnesses are in the charge sheet. So primarily, the complainant, the person who went to the police station to complain about you that you have committed a crime against him, will be the first witness to testify. Now, when the prosecution will say they are ready to proceed with their case, the court will give you a time allocation, a time to which you can proceed now with your hearing. Let's say the court has normally started at 9, they will say we can proceed with your prosecution hearing at 11 o'clock. So you go back, wait. You can even go through back the witness statement. You will just check them as you wait for your time. Now, as the accused person, your matter will be called at 11. You will go sit there. Then the prosecution will bring their witnesses one by one. And this is where I want to explain what happens when you're questioning the witnesses. So number one, the prosecution will lead their witnesses, will ask their witnesses to give an account of what transpired. This is what we call an examination in chief, where they will ask them, what is your name? What crime was committed against you? Which day was it? That is called examination in chief, where the witnesses is led to give out the story of why it went and it led for you to be accused of the crime that you have accused of. After the person has done what we call an examination in chief, now it is the time for your advocate to question the witness statements or the evidence that the complainant has brought before court. And this will apply to all witnesses until the last witness, who will be the investigating officer. So your advocate will do what is called cross-examination. So cross-examination is where your advocate will ask questions to confirm or deny the allegations made by the witness. You will question beyond reasonable doubt so that the court can see the weighing of the evidence that is before court. After your advocate has asked the question in cross-examination, the prosecutor will then come back and do what is called a re-examination. On the questions your advocate has already asked, the prosecution will try and confirm maybe something that the witness said that was not actually what he meant when he was answering your advocate in cross-examination. So this will go on for witness after witness after witness. Eventually, all the witnesses will be done, and the person to close the witnessing for the prosecution will be the investigating officer, who will make a summary of all he investigated and what the witnesses said until he thought it best to bring you to court. So after all the witnesses are done, then the court will say you can go back and write submissions. Submissions are documents that advocates write to confirm what was stated in the court. From the first witness to the last witness, supporting it with any cases that have been determined before similar to your case, so that the court can make a finding if you have a case to answer or not. Finally, when now we have reached the end, we have made our submissions, we have confirmed, we have put our submissions, both the prosecution and the defense, the court will give a ruling date. This ruling date is where the court will make a determination. Do you have a case to answer, or you don't have a case to answer? If you have no case to answer, the case ends, because the prosecution has not proven that you have a case to put yourself in defense. But if the court says you do have a case to answer, the court will say, how many witnesses do you also want to bring? And how are you going to give your statement? Is it going to be a sworn statement or an unsworn statement? So this is what we're going to deal with in the next video. I hope this has been very clear. If you have question, kindly put it in the comment question. And as usual, like the video, share the video. Subscribe to my channel. When you subscribe, it reaches more people. I hope you'll have a nice weekend. And until next time, God bless.